on to our ongoing deep dive series based on Q&A from clients who interact with Chowdhury Law Office, usually as a prelude to a consultation and retaining us for Canadian immigration legal services. I'm Max Chowdhury, and over the next few periods, I'd like to explore why the phrase simple immigration application is the biggest myth in this industry. For people who are joining, please feel free to pose questions in the chat. Keep in mind that I recommend you try to anonymize the question because portions of this webinar will be posted on social media. And for that reason, anonymity is essential. But I will endeavor to provide some general guidance to your question that you do pose in the chat. People typically come and go from time to time during the course of this webinar, once their questions are posed and I provide some kind of direction. And that's obviously fine because this is just meant to show that we are here to provide some general guidance. And if you retain us, our legal services through our law firm, law office, then we can be retained to serve you in a more substantive way. But I'm just going to take a look at the box to make sure that any questions that are present, I can try to endeavor to answer those. And obviously, the basic question is, I'm presuming you can hear me for this. For people who are joining again, to keep in mind, the portions of this would be posted on social media. So it may be your preference to keep your voice and your camera off, but merely pose questions in the chat for this. If I don't see any questions, I'm just going to take the time here to answer questions that people had sent me before the webinar, and they may or may not show up today. But in the meantime, while I go through those questions, feel free to type out the questions that you have in the chat box, and I will try to get to those. And if they are lengthy questions, the format might be that you pose the question simply, and then if I give a response that requires more detail, I might indicate that more detail is required, and you can provide that detail in the chat as well. But in terms of the sort of overall scope, what I want to convey today is some of the questions and my responses based on the questions previously posed. So let me start with an analogy. Immigration law isn't a highway where you just get in the right lane and drive straight to your permanent residency. It's a high-stakes game of chess, in some cases, played on a board where the rules change almost every time you make a move. So with that in mind, let's look at the temporary worker landscape. Many people think or thought, now that we're in 2026, that a post-graduation work permit, or PGWP, is a golden ticket. But a PGWP is more like a single tank of oxygen on a scuba dive. It gives you a set amount of time underwater or time in Canada to accumulate work experience. But if you don't secure your next tank before it runs out, you have to surface immediately or return to your home country. I regularly see frantic corporate clients whose major projects are put on hold because a key employee's PGWP expired. They lost all their status, and the subsequent labor market impact assessment was refused. You can't just apply again without a strategic overhaul. When an LMIA is in process, but the work permit is expiring, or when an individual gets laid off while waiting for an approval, the options to remain in Canada become incredibly narrow and require precise legal navigation. So, with that in mind, let's get into some specific scenarios. And again, if you're joining, please feel free to pose a question in the chat. I'll try to answer that. In the meantime, I'll go back to the questions that were previously posed, unless I see something. Oh, I do see something here, so let's get to that in the meantime, and then I'll continue with the presentation. So, If I'll try to distill the question, because some people who are watching this on social media won't have access to the chat box. So when I look at the question posed here, it says, somebody was a permanent resident of Canada in 2008 when they were 6 years old. Parents moved back to India. So that implies this individual, he or she as a child, went back to India, and they went to take care of this person's grandparents in 2009. So about a year later. And this person reiterates that they were a dependent on the parents. And as such, they had to return to India. In terms of the further detail, the person's PR card expired in 2013. And when asked for IRCC in, I believe, 2026, they indicated to this person that they were still possessing permanent resident status. And they said it is active in the IRCC system. And they suggested applying for a PRTD, a permanent resident travel document. And they indicated by email that the PR obligation, or the permanent resident obligation to maintain 730 days in a 5-year period, was required, but renewal is not totally dependent on it. And a renewal is possible as well. So I've come across this question 1,000 times, but I will pose it because people in the online audience may not know the question. In that scenario, is it possible to reinstate this person's PR card? And have you seen any case like this? So this is where caution in the extreme is essential, because in this scenario where you probably did not meet the minimum 730 days in a 5-year period, you must tread carefully, because when somebody files a PRTD application, by definition, you are outside of Canada. And by definition, you do not possess a PR card, which allows you to board an airplane. So this is I would euphemistically call it the legal safety valve for this situation where your card expired, maybe beyond your control, and you want to return to Canada and you still have PR status. That PRTD application has to be done with extreme caution, because the PRTD application, if assessed by a Canadian visa officer as negative, means that your status is taken away and you have no choice but to seek an appeal at the Immigration Appeal Division of the Immigration and Refugee Board. Usually you have, I believe, 60 days from the date of that refusal to initiate that appeal. Keep in mind that when you initiate that appeal, whatever you submitted in that PRTD application would be part of the disclosure, which can be used in your favor if you did it well, or to your detriment at the appeal if you did not do a PRTD application properly. So the factors the officer weighs when you make a PRTD application, in this case, would include humanitarian compassionate factors. And if we try to triangulate the humanitarian compassionate factors that an officer would look at in the case of somebody who failed to possess the minimum 730 days in the previous 5 years, the key elements would be, what were the circumstances? So, was the failure to accumulate the days in Canada beyond the control of this person? Did they make the attempt to reacquire or to regain the PR days in fashion as soon as reasonably possible? If this is demonstrated in the PRTD application, then the chances of success would be higher. On the other hand, if this was not done, then you could lean on H&C, or humanitarian and compassionate grounds, but they have to be very compelling. People say, what are compelling humanitarian compassionate grounds? If I try to describe them in the most umbrella 10,000-foot overview description of compelling humanitarian compassionate grounds. Usually there's some issue with life or limb, which is the same thing as saying physical or mental issues. That is one sort of giant umbrella category. The other ones are more niche, which would relate to, for example, if there's a legal impediment preventing you from leaving the country where you're trapped and you cannot return to Canada. I've had clients who had a family law dispute in India. They could not leave because the court ordered that their passport be seized. That was a very compelling case. They could not come back to Canada. They could not make the PR residency days because their passport was seized. They could not leave the country of India. Very compelling case. So these are some of the more cogent examples of compelling humanitarian, compassionate circumstances. Whenever there's any kind of serious humanitarian compassionate case, we always suggest a comprehensive consultation because we want to get a sense of you and your extended family's life circumstance, and we want to distill what that life circumstance might end up being relevant in relation to compelling humanitarian compassionate circumstance. So when I do these consultations, I have a rough mental questionnaire in my head because I've done this hundreds of times, where I end up probably posing 30 questions in a respectful way, because to do a proper consultation, you don't just ambush a person with 30 questions nonstop. You listen to their you listen to their answer. That may make me revise the questions I have after listening to their response and steer the sort of mental checklist of questions I have into a different direction. So anything to do with humanitarian compassionate, it would really benefit from a comprehensive consultation where we, in fact, even try to get documents related to the issue beforehand so we can prepare and review those and then have a more focused consultation session with the person and then give them the straight answer about what the risks are and what the likelihood of success would be as reasonably as we can with that background information. So I hope that provided some background to the interrelationship between somebody who has been outside of Canada on a lapsed PR card and the likely pathway for them to return to Canada, despite not having a valid permanent resident card, perhaps using the PRTD application with the caveat that a PRTD application, when negative, may simply trigger the immediate loss of your PR status, necessitating an appeal at the IAD. So if there's any other question, please feel free to pose that. I want to continue with the questions that were posed online for this. So the scenario I was discussing online is when this tactic, which we saw particularly before 2026, with this proliferation of LMIAs, the Labor Market Impact Assessment. This was sometimes used as a possible tool to extend the PGWP, which usually maxes out at 3 years. But what if you get the LMIA assessed positively, then you're fine. And as long as the LMIA is issued before your PGWP or your post-graduation work permit expires, then you could simply extend the work permit based on this LMIA, which is usually a closed work permit. But what if it's refused? You simply cannot just apply again without that strategic overhaul I was suggesting. So with that in mind, the options to remain in Canada legally become incredibly narrow and require precise legal navigation. So it's something to keep in mind that may necessitate doing an LMIA, maybe doing a work permit, but that may necessitate you leaving Canada in the event that the LMIA cannot be reissued. because you don't want your status to be lost. You could stay in Canada perhaps as a visitor, but that may make getting the work permit on the subsequent LMIA more difficult. So, in these circumstances, let's switch to another question. This relates to provincial nominee programs and express entry. So, when temporary workers try to transition to permanent residency, they often look at express entry or provincial nominee programs, also known as P&Ps. But again, navigating these is like trying to find the exact key for a constantly shape-shifting lock keyhole. For example, I recently analyzed a case for an international graduate with a postgraduate certificate in design. The federal skilled worker program was a backup, but they needed specific point thresholds. These days, it's over 500 points. We had to look at the Ontario Immigrant Nominee Program, OINP, the Rural and Northern Immigration Pilot, or RNIP, and the Atlantic Immigration Program. But here is where expertise matters. You have to know the current political and economic targets. When we were looking at this in 2025, the immigration targets had been revised downward, making draw sizes smaller and the comprehensive ranking system, or CRS cutoffs, higher. To win, or to get the minimum point threshold to be invited, you must align with category-based selections like French language proficiency, healthcare, certain STEM occupations, or agriculture. You cannot just throw an application into the pool and hope for the best. You have to tailor your client's career trajectory to the specific economic demands of the province. And this is where consulting us before you embark on a proposed program of study in Canada could be invaluable, because we can try to, like throwing darts, you can try to select a program or a course of study where there will be demand in Canada when you graduate, and that would make the likelihood of getting a PGWP higher, and in turn, a higher likelihood of acquiring permanent residency through, for example, Canada Experience Class, CEC. This way, you can tailor your client's career trajectory to the specific economic demands of a province. So with that in mind, I'll look at the next question I see here. This relates to spousal sponsorships and procedural fairness. Even family sponsorships, which in some cases seem straightforward, are fraught with hidden traps. What happens if an international student files for a spousal open work permit, but the school fails to confirm full-time enrollment, or a designated learning institution, or DLI, number is missed in the study permit application, leading to the spouse getting refused? What happens if the officer doubts the financial dependence of the spouse based on the bank statements that are presented to the immigration department? That would be another refusal. Or consider an inland spousal sponsorship where an officer issues a procedural fairness letter, a PFL, demanding timeline documents or questioning why life insurance beneficiaries were set up a certain way before marriage. This leads to questions about the genuineness of the relationship. So a PFL is IRCC's way, or the immigration department's way, of saying, we're about to refuse you unless you give us a brilliant explanation with cogent evidence, and hopefully a legal framework to guide the officer. Responding to a PFL requires meticulous evidence gathering and legal framing, not just a casual letter of explanation with fingers crossed. So when I look at other situations, let me turn to another question for this. And this relates to the more technical and complex issues, such as inadmissibility, humanitarian grounds, and a very narrow niche issue of cessation of already acquired protected person / refugee status. So when the standard pathways are closed and the client is out of status, which we've seen, or facing removal, or dealing with a severe criminal or medical issue, then cases can become more complex. Sometimes the pathway or suggestion relates to H&C or humanitarian compassionate applications. Filing an H&C is not a standard application. Depending on your circumstances, it could be what we call a Hail Mary pass in the final seconds of the game. It is entirely discretionary. There is a legal framework, but it's posed in immigration bulletins and immigration officer guidelines. They're non-binding, but sometimes persuasive. I've reviewed legal and refusal decisions that perfectly illustrate how strict officers can be in these situations. In one case, an applicant claimed establishment in Canada because they donated blood and gave money to a temple. The officer's response: insufficient evidence. They wanted to know how often the blood was donated and wanted to corroborate proof of ongoing volunteer work, amongst other necessary documents supporting an H&C application. Officers also heavily scrutinize the best interests of the child, or the BIOC, and hardship upon return to the home country. It's not enough to say, my country has corruption, or we will have problems back home. You must prove a personalized, disproportionate hardship. For instance, demonstrating that a child requires specialized medical accommodations, like intensive treatment for epilepsy or autism, that are demonstrably unavailable or discriminatory in their home country, could form the basis for a strong H&C application. Similarly, for H&C applications, we have admissibility issues like criminality, sometimes coming up at the border or port of entry. A past mistake a person committed in these situations is like a shadow that follows you right to the Canadian border. I've dealt with cases involving decades-old DUI convictions, past drug possession charges, or severe situations like a commercial truck driver facing vehicular homicide charges in the US after a tragic highway accident. These aren't just hiccups. They render you criminally inadmissible to Canada. Even an Interpol red notice discovered during a layover in the UAE can trigger a massive cross-border legal crisis. Resolving these issues requires complex admissibility hearings, temporary resident permits, or criminal rehabilitation applications, or in some cases, dealing with Interpol to find out the merit of the red notice. These are the courses of action we have to do in the complex situations. So in other situations, let's look at who else posed something here. Oh yeah, so then there is the fragility of refugee status or protected person status. This area of law is incredibly delicate. So imagine someone who sought asylum in Canada years ago due to persecution based on their sexual orientation under their home country's penal code. They gained permanent residency in Canada as a protected person, i.e. a successful refugee claimant. Years later, the laws in their home country change and they decide they want to apply for a passport from their home country to visit. This is a horrific legal landmine in this situation. Applying for a passport from a country you fled can trigger cessation, meaning the Canadian government could argue that you are reavailing yourself of that country's protection, and they can strip you of your Canadian permanent residency. So you must get advice in certain situations. Even if you said, I didn't know getting a passport would trigger the loss of my refugee status, or at least the potential loss of my refugee status, ignorance won't help you. You can dig yourself out of that hole with proper legal advice. This could lead to representation at the Refugee Protection Division of the Immigration and Refugee Board, where they would determine holistically if you actually intended to reavail yourself of your country's protection. So As you can see, immigration law is a living, breathing, highly volatile system with some idiosyncratic rules. A single misstep, submitting the wrong bank statement, misunderstanding provincial statistics about labor market needs, or renewing a passport at the wrong time in the wrong circumstances can result in years of litigation, federal court appeals, and perhaps broken families. So those are some of the cautionary issues I want to bring to your attention based on some of the questions that have been posed to me over the last 4 weeks. So let me proceed to further questions here. And before I see that, I do see another question in the chat. So let me go to this question now. So again, I'm going to distill the question for people who are going to just come across this or stumble across this online. So they don't have to, because they do not have access to the chat. So this indicates a person's friend applied for a PR in January 2026 through H&C, Humanitarian and Compassionate. She's yet to receive an AOR, or an acknowledgement of receipt. Now, her current study permit has just expired. So the question is, can she apply for a TRP, or temporary resident permit, in the meantime, so she can have a status while she continues to wait for the outcome of her H&C application? Or can she go through the healthcare pathway for nursing and health-related programs like the Alberta AIPP program? So this is really two specific questions, both kind of complex. So in terms of the first question, if there's an ongoing H&C or humanitarian compassionate application, that's a signal that you intend to stay in Canada. So merely filing a temporary resident permit inside of Canada would not really be sufficient enough for this. A TRP, contextually speaking, is meant to correct immigration violation. For example, if you had been out of status already, then a TRP would be the way to go. In this situation, they've indicated the permit has just expired. So in theory, if the status of study permit holder has just expired, a TRP could be a tool to try to regain status. This is where the questioning and comprehensive consulting would come into play, because this person would have to weigh the benefits of staying in Canada, trying to file a TRP, keeping in mind that a TRP in and of itself, while it is in process, does not maintain any kind of status. Something that does maintain status is if you have a study permit that expired less than 90 days from the date of today, then today you could try to restore status. And that way you could remain in Canada legally. In that scenario, a TRP, strictly speaking, would not really be necessary or strategically beneficial. So that's one thing to keep in mind about at least the first aspect about maintaining some kind of status in the midst of or in the middle of an ongoing H&C / humanitarian compassionate application. The other leg of this question relates to the fact, well, just for the sake of completeness, again, if I was not clear, then filing a TRP does not automatically let you stay pending the decision on the H&C application. I just want to make that extremely clear. For the other element of this, is there another pathway for PR over and above or separate from the humanitarian compassionate pathway, such as the healthcare pathway for nursing and related programs, such as the one in Alberta? So these ones, if I recall correctly, because there's a lot of minutiae for these provincial programs, some of these require licensure as a nurse and or a job offer. If those are in place, then The other thing to explore is whether these programs, these Ontario programs, require you to have valid status. Going by memory, a lot of these require you to have valid status. So if you don't have valid status, you may have to leave and pursue these provincial nominee programs outside of Canada. So then there's no issue of trying to shoehorn your circumstances into a rigid Ontario or Alberta program while you lack status. It just doesn't look good because the Ontario programs don't want to look like they're facilitating or encouraging you to maintain a loss of status. So that's sort of the other, I think, response to the question I'd want to say in this kind of situation. So if there's any other people posing questions, by all means, please feel free to do so. In the meantime, I'll go to the questions that were posed ahead of this chat, and presumably they will find the answers if they stumble across this on social media. So in these kinds of situations, family reunification is one of the pillars of the Immigration and Refugee Protection Act. It's in section or regulation 2. I'm going by memory again. But this doesn't mean that they're necessarily as straightforward as, for example, an LMIA job offer or entrepreneur or business case. So in these applications, let's think of another analogy. So applying to sponsor a family member is like building a house on a shifting foundation. You might have the blueprints perfectly drawn, but the government inspector can change the building code halfway through the construction. So let's talk about procedural fairness letters in these family class or spousal cases, in spousal sponsorships. These are not polite requests for information. They're loaded weapons. I recently handled a case where an inland spousal sponsorship triggered a PFL because of life insurance. The applicant had obtained a policy prior to marriage with their parents as the primary beneficiaries, and only later changed it so the spouses mirrored each other as beneficiaries. To a normal person, this is just financial planning. To a skeptical immigration officer, it looks like a marriage of convenience. We also see PFLs issued when a sponsor previously failed to declare a common law partner, leading to allegations of material misrepresentation under Section 40 of the Immigration and Refugee Protection Act. So responding to these requires aggressive documentary evidence and a bulletproof timeline, and you can try to exculpate yourself from the allegation of non-genuineness of the relationship. Then there are on the other hand, the very heartbreaking H and C cases for extended family. Consider a scenario where a permanent resident wants to bring their 47-year-old widowed mother and 14-year-old sister over. The father recently died, leaving them with no support network, trapped in a region with severe safety and crime issues in their country of passport. You cannot simply ask IRCC to be sympathetic. We have to meticulously document the exact financial assets left behind, prove that the lack of extended family support in the country of origin, and legally frame how the mother's only viable lifeline is to the child with Canadian status in Canada. Merely stating these things is insufficient. You need exhaustive, highly probative evidence to prove this on the balance of probabilities, which is the legal standard. So with that, I'll look at another question from the previous chat for this. So when we see border issues and criminal inadmissibility, these criminal charges, when you approach a border, are like an anchor. You might forget it's there, but the moment you try to sail across the border, it catches you and drags you under, or maybe even has you detained or told to leave the border. Criminal inadmissibility does not care about how much time has passed. I regularly consult with people dealing with a 15-year-old drunk driving or DUI offense, or a spouse with a financial conviction a long time ago, or once even a cocaine possession charge from the early 2000s. These don't just wash away. They require complex criminal rehabilitation applications and or temporary resident permits just to attend a family event in Canada or something like maybe going to a vacation cabin in Canada in a cottage. So let's look at how fast things can escalate. Imagine a commercial truck driver working in the United States. He gets a flat tire, pulls over, and a police officer instructs him to move the truck to a safe location to wait for a service call. He drives 30 miles per hour with his flashers on, but tragically, someone rear ends the truck and dies. Suddenly, this driver is facing a felony charge in the United States for a vehicular homicide under a state code. The local U.S. lawyer might advise taking a misdemeanor plea trial under the U.S. criminal system. But as Canadian Immigration Counsel, I would have to look at how that specific foreign statute equates to the Canadian Criminal Code. A simple plea deal to avoid jail time in Nebraska or Oklahoma could result in a lifetime ban from Canada. But even without a criminal record, the border is perilous. We've seen international students whose study permits expired, who incorrectly, let's euphemistically call it, went to an interview booked by customs after their foreign passport was seized. Walking into a CBSA interview without status and without legal counsel is practically volunteering for a removal order and to be deported. So these are the cautionary tales, some a bit more dramatic than others, to keep in mind when there is some kind of inadmissibility, such as criminality, affecting your potential ability to visit or reside or work or study in Canada. So I'll look at some other questions in the previous ones. Just one second here. And all right, so now when we see refugee status, which is another question we get from people who are inside of Canada, oftentimes. When you have refugee status or you have PR, there's a sense of relief. You feel secure. It's like an oasis of sorts. So, but if you step out of that oasis, the doors might lock behind you. So this relates to a similar question from before. The cessation of refugee status. So suppose a client sought asylum in Canada years ago due to severe persecution based on their sexual orientation, and the client gets the Canadian permanent residency. But if the home country repeals the anti-homosexual laws, the client applies for some document issued by that country and they want to visit. Again, that's reavailing status. So Canada can strip them of their refugee status and protected person status through the process of cessation at the Immigration Refugee Board Refugee Protection Division, or RPD. There's a test under the legal case of Cameo. You can Google that if you're in this situation, which can give you the criteria that the Refugee Board uses to determine if the refugee status should be ceased, or in the idiosyncratic language of Canadian immigration law, cessated. Then we have the victims of incompetent or illegal consultants. Ghost consultants is the colloquial term. I reviewed a tragic file based on this question, where a family filed a refugee claim using a consultant who literally copy-pasted phrases from other people's refugee stories. The claim was inevitably refused. The client only discovered the consultant did nothing when they were called in to a CBSA appointment in the Greater Toronto Area, that is at 6900 Airport Road, near the airport, oddly enough. The CBSA demanded that they obtain a passport for their 18-month-old child to facilitate their deportation. That child was Canadian. Now, meanwhile, the wife is 4 months pregnant and dealing with severe stress and deteriorating healthcare access. Fixing this would require, if possible, an emergency stay of removal at federal court, which is high stakes litigation. A stay is a request to the federal court to pause the removal while these life-changing, potentially life-threatening issues are dealt with in Canada. So, things to keep in mind when you have a complex situation such as this. However, even standard permanent residents face a loss of status based on this question. Take a client who got PR but had to move to China to escape an abusive ex-spouse. They got trapped abroad during the COVID restrictions. They have a Canadian-born child with severe ADHD who faces abuse and a lack of medical accommodation in foreign schools. To get them back to Canada, we can't just buy a plane ticket. We have to file a highly complex PRTD, or permanent resident travel document, arguing humanitarian and compassionate grounds based on the best interest of a child and explaining the reasons, in this case quite dramatic, the reasons for being unable to return to Canada with cogent evidence. So now if we look at some other questions here, so let's look at corporate immigration, because this happens from time to time. So securing a labor market impact assessment, or LMIA, in some cases is like trying to hit a target while blindfolded, while the government actually moves the target, which is a very flowery way of saying that LMIAs are subject rather to government policies. Some of these policies are not available to us and are brought to our attention while the LMIA is in process. So this requires dealing with the client and ESDC Canada, the department dealing with Service Canada, in a highly adept and adaptable fashion. So LMIAs are not just about filling out forms. They're about administrative law and statutory interpretation. We've had to literally fight Service Canada directors over their use of statistics. In one corporate case, Service Canada tried to refuse an LMIA by using provincial labor market statistics to assess the job market, rather than the regional statistics that actually reflected the employer's local advertising efforts. So when the government, in this case ESDC Canada, moves the goalposts, you have to be prepared to take them to federal court. The human cost of these bureaucratic delays is immense. Imagine a worker who has been with a Canadian employer for 3 years. Their open work permit expires, so the employer applies for an LMIA to keep them as an employee. But the LMIA processing time takes so long that the company is forced to lay the worker off while they wait. Now the worker is sitting in Canada, perhaps as a visitor, out of a job, bleeding savings, waiting for a government decision just to know if they have a future here in Canada. Or consider a senior manager whose work permit is expiring. The company has applied for an LMIA, but they are stuck in processing purgatory, I call it. This isn't just an inconvenience. This manager has a young daughter, underage, with a medical condition, who needs intensive care unit care. If the LMIA fails and they're forced to return to their home country, the local schools there have no training to deal with a child with this kind of medical condition, and the medical system cannot accommodate her. So when you look at these scenarios coming from these questions, from vehicular homicide charges in the US to Service Canada misinterpreting or using the wrong labor statistics, to the CBSA demanding passports for toddlers, even Canadian ones, you realize that Canadian immigration is not a paperwork exercise. It's a highly aggressive, deeply complex legal battlefield where you have to marshal relevant evidence, exclude evidence that could damage your position, and frame it in a legal kind of framework in accordance with immigration government laws and policies. So these relate to those admissibility questions. So if I go to any further questions, For this, we want to look at the other scenarios related to simply visiting Canada in the midst of a refusal or two. So instances like this, we come across from time to time. Just one second. The issue with visitor visas and, from my understanding, also study permit applications and maybe even work permit applications, is that the Canadian government is using artificial intelligence to assist in these types of applications, given the scope of volume of these temporary applications versus PR applications. And also, perhaps the stakes may not be quite as high in these types of applications. The problem with artificial intelligence that we've encountered is that in some cases, when these refusals for visitor status are taken to court, it's discovered that artificial intelligence was involved in the decision making. In these cases, at least in the cases we've dealt with, the artificial intelligence provided a summary, but did not completely look at the evidence that was submitted by the client to support their visitor visa application. The evidence that was missed included comprehensive passport stamps showing this person had entered many developed countries and came and went. In other words, this was cogent evidence that this individual had the opportunity to visit many, many countries and had the financial wherewithal to visit these countries and did not stay, but rather complied with the terms and conditions of a visitor to these Western and European countries. That evidence was missed by the officer when looking at the summary that was generated by the artificial intelligence. So the case was taken to federal court. The federal court agreed that the evidence was not fully considered. And it's an error for a Canadian immigration officer to fail to consider highly cogent evidence in relation to the goal/application being pursued, in this case, a visitor visa application. So the case was erased. However, when I'm looking at this previous question, this individual says that their application was very good. It had scope of travel to many countries, good financial evidence, obligation to return to their home country because of their business, which was very successful. So it was refused. In this case, one issue that can come up in these cases is maybe in the past you had one refusal. And by contrast, maybe 5 years later, your life became much more successful. You acquired your own business. It's very successful. You've traveled to other countries besides Canada. Now you want to visit Canada 5 years after the refusal. Sometimes the artificial intelligence encourages a refusal merely because of the one refusal in the past. So this is analogous or similar to simply failing to look at the big picture of the visitor visa application, looking at the more recent circumstances of the candidate showing that they have visited other countries and returned and have a very good degree of economic establishment in their home country and have an incentive to return to their home country because that's where their business lies and maybe their family. This is a sort of misapplication of artificial intelligence. And in this situation, the options, generally speaking, are for the person to resubmit the application or to, if they have for the financial means, to go to federal court. However, what if, as we've seen in some cases, what if the person with a very good set of visitor visa facts, good business, good travel history, family ties in the home country, what if they resubmit this a second time and it's immediately refused after 3 days? You don't have a choice in this instance. You either give up on visiting Canada or you go to federal court. The strong assumption is that a situation where you had good evidence, but one refusal, which is less relevant because it was in the past many years ago, in a situation where that case is refused immediately after resubmission, leads to a strong inference that artificial intelligence steered the officer's decision to a refusal without looking at the evidence. So this is an issue where artificial intelligence could wrongfully lead to a refusal, leading to a possibly very expensive remedy. In these days, the Immigration Department issues what are called the GCMS notes with the visitor visa refusal, which can give some insight to the reason for the refusal and can give a clue about whether or not there is some value to resubmitting the application or to proceeding to federal court. So legal advice is highly advised because we have experience about how the court system works and how the IRCC temporary resident visa system works. And we interact with other lawyers who can provide other insights about whether the case that you have, temporary resident visa or PR case, should be refused and taken to court, or if it's refused and reconsideration could be an option for this. So I'll look at another question, nothing in the chat today, but the previous questions I can go to, and this relates to study permit applications now in 2026 pathways. So this person is interested in studying in Canada in 2026. Now, the situation, by contrast, compared to prior or pre-2024 is a lot different. The landscape has changed. Amongst the requirements are a provincial attestation letter, which is a finite amount, a kind of a funnel by which provincial learning institutions are issued a finite amount of these. So that's a prerequisite. To get a provincial attestation letter means you typically have to pay a deposit at the learning institution in Canada. Then you have to think strategically about these potential study permit applications, because the scope of PGWPs, post-graduation work permits, which would normally be issued to anybody with a 2-year graduation program or higher at a publicly funded school, in the future will be restricted. I mean, they already are now. Now you have to have a language test to get a PGWP, but they'd be further restricted in the sense that they want to issue PGWPs only if there is a demand for what you have studied in Canada. So this would mean that you would have to divine or predict in 2026 whether the course of study you are pursuing in 2028, if this policy goes into effect, you'd have to try to figure out if the course of study that may take 2 to 4 years, in other words, by 2028 to 2030, would put you well placed to be competitive in the Canadian labor market, and that would be recognized by the immigration authorities in a presumed list saying, yes, this is the list of occupations that we would issue a PGWP for. So that's something to keep in mind if you're contemplating study permits as a pathway to permanent residency, because now, and in the foreseeable future, the Immigration Department is no longer necessarily looking at this as a pathway for PR. It's more like the pre-2015 regime, where a study permit was meant to provide you with the skills and education that would allow you to re-enter the labor market in your country of ordinary residence / country of passport to further your career. Because, for example, the course of study that you intend to pursue in Canada is not available or not readily available in your country or in an adjacent country where presumably the course of study might be cheaper. So you'd have to be strategic about this, saying the study program is only in Canada, or it's of a certain quality, a higher quality in Canada, in order to try to acquire a study permit now in 2026. This is not the same as a study permit for people who are going to primary school or secondary school. It's not as rigid, so it's something to keep in mind. If you're well off and you want your child to study in Canada, it's still pretty straightforward. So I'll look if there's any other question, not from the Today chat, but from the previous chat. Oh, yes. Okay. So this one, somebody posed a question about coming as an intra-company transferee. So this type of work permit does not require an LMIA, or Labor Market Impact Assessment. This is under the subcategory of the international mobility kind of genus or species of work permit. So what's required, generally speaking, for this is the person has to have an employer with a branch in Canada, and this person in the outside of Canada branch has to have worked for 1 year in the past 3 years for that outside of Canada branch, and they have to have a job offer from their Canadian branch, and the job offer has to relate to executive level management or specialized / maybe proprietary expertise. So that's the very, very basic framework for this kind of intra-company transferee program. This individual is a bit different because they want to establish a branch in Canada. So for this kind of situation requires probably a business plan to show that the home / outside of Canada branch has the financial wherewithal and a business rationale, as illustrated through a business plan, to say that we're expanding in the Canadian and or North American market. So this necessitates bringing either an executive or a specialist of some sort to work in Canada to further the business goals of this putative or potential Canadian branch, and thereby further the income of the company as a whole, because they would be affiliated companies. So the business case has to be made. Immigration officers, there's a stereotype that they don't have any business expertise. That may or may not be fair. So a cogent business plan is meant to guide them about the business case. That doesn't end the analysis. Obviously, the candidate has to show they worked for 1 year in that branch. A secondary issue, if they've already worked for the branch, the secondary issue is, do they have the skills and expertise? Presumably, yes, because they've already worked for that home or outside of Canada branch. So that's sort of the essential underpinnings of intra-company transferee. It's obviously more difficult if you want to establish the company and then dispatch or second the employer or the employee to the Canadian branch in this situation. So that relates to most of the questions. I'm at time. So I want to thank you, people who posed questions beforehand, and anybody who posed questions here. I hope this was useful. So my name is Max Chowdhury. I'm an immigration lawyer. I've been one for 31 years. My law firm, Chowdhury Law Office, has almost 50 years of combined experience based on the lawyers at my office with my experience. And for the reaching out, there's the website for this. That's the www.chowdhurylaw.com is the website. And thanks so much, and enjoy the rest of your day or evening, as the case may be.